minutes. Mr. Director, the recent revelation of the NSA data collection programs has led to a great deal of debate both in Congress and in the public. I know there is very little you may be able to say in a public setting, but to the extent you can, please explain to this committee why you think these programs are important and how they protect the American people from terrorism. Do you share the concerns of many members of Congress, including myself, and American citizens, that civil liberties need to be protected in the operation of these programs?
Well, let me start by saying that the challenge in a position such as I have held for the last 11 years is to balance, on the one hand, the security of the nation, and on the other hand, the civil liberties that we enjoy in this country. And there is not a day that goes by that we don't look at some issue that raises that balance. One of the things we do insist upon and assure, and that is any endeavor we undertake addressing national security is legal. In this particular case, the programs to which you refer, the legality has been assured by the Department of Justice. The FISA court has ruled on these two programs, monitors these two programs, and again has assured the legality of the efforts undertaken in these two programs. And lastly, I will say, in response to what the Ranking Member Conyers said in terms of a debate, Congress has been briefed, as has been pointed out, has been briefed over the years, was briefed prior to the 2009 re-up, was briefed before the 2000 re-up, in an effort by the administration to make certain that Congress knew and understand the efforts that were being undertaken under Section 215. And if there were a change to be made by Congress, if the line is to be drawn differently, so be it. We would follow that to the letter of the law. But I repeat that in both of these programs passed by Congress, they have been approved and the legality assured by the Department of Justice, by the FISA court, and have been briefed. And
so let me interrupt you because we do need to get a couple more questions in. And I think you've made your point on that, and there'll be sure further discussion about it before the day ensues. As you know, the committee is investigating the use of the Privacy Protection Act of 1980 to obtain a search warrant for Fox News correspondent James Rosen's emails. In your experience as a federal prosecutor, as assistant to Attorney General Thornburg, as Assistant Attorney General of the Criminal Division, and as FBI Director, when you authorized a search warrant for a target of a criminal investigation, wasn't prosecution of that target the objective?
I would say no, that quite often in search warrants there are or affidavits in support of search warrants. There are occasions where a person will be mentioned as having culpability, but there will be no discussion or anticipation of prosecution. That could be for a variety of reasons.
Well, to that point, in the case in particular with regard to Mr. Rosen, and perhaps in other cases where you did not intend to prosecute, did you characterize the individual as a flight risk, as was done in the matter involving Mr. Rosen? And did you delay notice of the search warrant for 18 months, as was done in the case with regard to Mr. Rosen? It actually turned to be 3 years because the judge neglected to release the information until 18 months after his order required that it be done, but the Justice Department requested 18 months in the first place.
I am not.
Why would that be necessary if there were no intention to prosecute?
I'm not familiar with the full extent of that investigation, in particular all of the facts that were raised either in the affidavit or in the discussion as to how one would proceed to get the data that persons wanted. I can say two things. One, that there was great scrutiny given at the local level, I am sure, to what needed to go into the search warrant and its affidavit, in particular with reference to the judicial requirements for getting those particular records. And secondly, that there is a protocol, long-standing protocol in the Department of Justice that was adhered to in getting approval for that particular action. I know and you know that the Department of Justice is now looking at this set of circumstances.
Let me interrupt you to get one more question in.
All I want to say is that to the extent that there are tweaks that need to be done, we're happy to abide by those tweaks.
Following the apprehension of Dzhokhar Tsarnaev, some criticize the timing of the criminal complaint against him and his initial appearance. We know the timing of these acts is set forth by the Constitution and the rules of criminal procedure. Do you believe these criminal rules are well suited to intelligence gathering from a domestic terrorism suspect? And should the Congress consider amending these rules when we are faced with a domestic terrorism situation, whereas in this case, the questioning of this individual by the FBI prior to his being given his Miranda warnings short-circuited your opportunity to question him about imminent dangers like other potential sites, other suspected co-conspirators, and other bombs that may have been in existence at the time, and therefore very important that the defendant, the prospective defendant, be questioned.
Any investigator would tell you, or interrogator would tell you, the longer you have, the more information that you get. Particularly in this day and age, where if you have access to information on computers or thumb drives or what have you, you will have a much better opportunity to get appropriate questioning accomplished. On the other hand, you have the dictates of the Constitution and the applicable statutes. In a very narrow sliver of cases where it is terrorism, where the threat is substantial, I would say that one could look at opportunities for giving those questioners additional time to extract information that may protect the public.
Thank you. My time has expired. The gentleman from Michigan.